All right, Tim Blankenship here with divorce661.com. We are a full-service divorce legal document preparation firm serving all courts in California. If you're looking for a full-service solution to handle your case anywhere in California and you're amicable, look us up, divorce661.com. Today we're talking about how to prepare your judgment when there's no assets, no debts, no kids, no nothing. You're just doing the dissolution of marriage. Let's get into it. All right, we're going to assume you've already filed and did your disclosures and had all those preliminary documents completed. And we're talking about just the judgments forms here in this video. So let's get started. We're going to mark dissolution. We're going to mark that's a default or uncontested. That's the kind of case we're talking about, default with agreement. The respondent was served with process. So this would be the date that they were either served personally or signed a notice and acknowledgement. You're going to put that date in there. Then you're going to mark box 4A. And by the way, this is for LA County only. I'm going to make specific videos for each county and all the various ways that this can be done. You're going to mark here number 4A, and you're going to mark number 1 on a specific date. For LA County, you're going to leave this box blank. The court's going to fill this in. This is all for legal separation and other things. We don't need to worry about that. There's no kids in this particular case. Name of the parties on the lines here. This is children, child custody, child support. We're not dealing with that in this video. Spouse support, we're saying no spousal support. Jurisdictions terminated, it means no spouse support to either party. As set forth in the attachment 343, which we'll be going over. And even though there's no property, we still have to attach a property order. I think a lot of people make that mistake. Okay, this is your face page. This is not your settlement agreement. Treat this as a cover sheet. Some people try and just turn this in as their judgment because it says judgment, but you have to attach these forms. And I'm going fast for you folks. You can always pause, rewind, and whatnot, but I don't want to make this video any longer than it needs to. The next form I'm going to cover is the 343 because that's the type of attachment it is. Let me move this over here. This would be the order that you would file this judgment, 180, 343, 345, because those are the attachments in the order that they have here on the 180. Going to the 343, so we're talking about no spouse support in this order. And so we're going to mark this as an attachment to the 180. The parties stipulate, just means agree. You don't have to worry about any of this. That's what's great about these forms. It looks complicated, but it's not. Page 2, you're going to mark the court terminates jurisdiction over the issue of spouse support for petitioner and respondent. That's it. Don't have to worry about any of this because there's no spouse support. Number 3, you don't have to worry about any of this as well. That is done. All right. 345, property order. Again, no property, but you still need to attach the property order. You can't just leave it blank. So you're going to just mark there are no community property assets or debts for either party. There's no community assets. There's no community debts. That's it. You don't have to fill out anything in here because there is no property. Look for another video on how we talk about listing property. For the, so no property for assets or debts, community or separate. Then for separate, we're just going to mark the box here and we're going to put none. And for respondent, none. That's it. This is your judgment. It's also known as your settlement agreement, stipulated judgment. It has all kinds of names, but that is considered your judgment. The 180, 343, 345. And then all I recommend you do, you need a place to sign and you just need to create a document that kind of looks like this. And this will go behind the 345. Just a place that says, hey, this is the judgment attachment, approved form and content, name of petitioner, response, sign, and it gives a place for the judge to sign. Because as you'll notice, there's no place for anybody to sign the settlement agreement. And on a default with agreement, you need to have that notarized. Don't forget that. So that is your judgment. Now there's procedural documents that you'll need. You're going to need your 144 stipulation and waiver or final declaration disclosure. You already did your preliminaries on the 141s, if you remember. And so you're going to waive your finals because they're not mandatory. Simple form. There's nothing to fill out. You just date and sign this. Because this is a default case, if you haven't already filed your request in your default, I always turn in our cases with the default, with the judgment package. You don't need this. You don't need to refile it if you already have turned it in. But if you haven't, you're going to mark is not attached, is not attached. You're going to put the dates and the petitioner's name, and there's 4 signatures. People miss this a lot. So date and name and sign. You're going to mark that a copy has been mailed to the request in our default has been sent to the respondent. You're going to put their name and address in here. Again, date, name, sign. Page 2, you're going to mark costs and disbursements are waived. Nothing else is mandatory here. Date, name, sign. And then in most cases, you're going to say I'm in regular communication with the respondent and know that they are not in the U.S. military service. Again, date, print, and sign. That form is done. 170, you're going to mark dissolution. You're going to mark everything in the petition is true and correct. You're going to mark default with agreement. You're going to mark this matter is proceeding by default. So this is kids support, don't need it. Spouse support, you're going to mark. I ask the court to terminate spouse support for petitioner and respondent based on a written agreement. And you're going to say, Tim, what is the written agreement? What are you talking about? The written agreement is right here, the 343, 345, and 180, where we said to terminate spouse support. That's it on this form. This form is done. Date, name, sign. 190 is your notice of entry of judgment. All you need to do on this form is add dissolution and then names and address for both parties on here. That is it, folks, for a default with agreement, no assets, no debts, no kids. This is the entire judgment package. That's all it takes to get your judgment. We did this under, how much time is on the clock? Under 7 minutes, and your judgment is done. I know it's going to take you longer to do it yourself. If you want help with your divorce, I'd be happy to take over your case at any point. This judgment package, by the way, you're going to want to turn all of this in at one time. The 180, 343, 345, and that signature page that I showed you right here, bring it in again. That's all going to be stapled together in that order. 180, 343, 345 signature page. And then you're going to have your original and copies of that. And then all those other documents I talked about, the 144, 165, 170, 190, those all are independent standalone forms. I hope you enjoyed this video. We're going to be doing this on all the different variations. So if there's assets and debts and no kids, or assets and debts and kids and spouse support, or any variation of that, I'm going to do that for each of the counties, and I'm going to do that for all the variations as well. We'll see you on the next video. All right, Tim Blankenship here, Divorce 661 Daily Perspective, episode 14. Back with you this Wednesday to talk about clients I helped, judgments we took care of for clients, issues clients are having, and just let you know overall what I do on a daily basis. So let's get into it. Today was pretty busy for a Wednesday. Usually I reserve this day for drafting settlement agreements, which we had a ton to do. Today I worked on 3 separate Santa Clarita settlement agreements. Santa Clara, they want a marital settlement agreement format versus the using of the forms. If you watch my videos, you know I'm talking about using the forms. For some reason, they don't like that. So we have to just comply with what they want. So we have a specific template just for Santa Clara because they do things so differently than every other county. I actually have a judgment reject sheet I've created just for Santa Clara because they do so many things different. In fact, I'm going to do a video talking about all the nuances with Santa Clara County, because if you're following my videos trying to do your own divorce, they might set you up for failure because Santa Clara is so different. Most of the counties, 50 odd, whatever counties we have in California, are 99% the same. Santa Clara, Kern County, and a few other outliers are a little bit different. But yeah, worked on several settlement agreements for Santa Clara today. Some are easier. Some people have a lot of assets. Some don't have many. Some take longer to prepare. Some don't have any. My fees are the same regardless. I never know what I'm getting into when people sign up for my service, but it all evens out in the end. A couple things I want to talk about as well. We had an Orange County judgment approval. And I always like to talk about the timelines. They're still running 3 months. I want to say that's an improvement. The last one we got back a few weeks ago was, I think, on the 4-month mark. And one thing to note on that is, I think I told you in yesterday's Daily Perspective that we're reaching out to courts as far as the child support reserved jurisdiction versus non-guideline order. And this judgment was approved with reserved jurisdiction, meaning no child support. And we're not having to turn the income and expense declarations in, which most people don't want to because it has a lot of financial data on there. So now I have that as a note for all our Orange County clients out there. If you, whether you want child support or not, we're not having to turn in the income and expense declarations there. So that's good. We started a new divorce case for a San Diego client. I think that's 2 for the week for San Diego. So we'll be helping them out. One was a judgment prep. One had already started their case and filed and served, and we're just about to do the response and get into that process. And we saved them that fee on the response. And then the other clients in San Diego are brand new, so we'll be starting them off from scratch. Took over another case for clients out of the Pasadena court. They had actually filed and responded, which is fine. Doesn't mean it's wrong. It's just that probably a wasted fee because they are still living together and they're amicable. But the good news on that is they don't have to wait the 30 days, even though it's an older case in 2022. But if it was a newer case, you wouldn't have had to wait. So there's a benefit to responding sometimes. But because their time's up because the response was filed, they don't need a notary. And I know you hear me talk about that a lot. In fact, the client from Santa Clara that hired me today, or maybe yesterday, I think it was yesterday. She specifically said, the response is filed, so we don't need a notary. And I think why she was asking is because she was out of country, and she probably watched the videos that say you need a notary from a consulate, which is a total pain. So filing the response is definitely a way of getting out of that. Plus, they had a short-term marriage anyways. It wouldn't have been a big deal. Okay, yeah, busy drafting settlements all day. I'm going to do a separate long form video just on Santa Clara. I think I talked about that already. Okay, next subject. You can't have an agreement on a true default case. And in fact, I've had, how many judgments did I have approved today? I had an Alameda County case approved. I think I skipped over that. The Alameda County took 3 months. No, I talked about that. Orange County took 3 months. So that's about the norm, except for Ventura, they're 6 months. LA still on track. We're still getting them done in 5 weeks. But true defaults, you can't have an agreement. So I had someone hire me to take over their case, and they had a settlement agreement attached, but it wasn't signed by the other party, and they're trying to submit that to court. And that's just not going to fly. If you either have an agreement or with that default with agreement, or you have a true default, meaning no agreement. So I've seen that a few times this year where people are trying to they say, hey, we're in agreement, but he's not signing or participating, or she. And so you can't do that. You cannot have a agreement with a default. If you're in agreement, and this is my last topic. I'm keeping today's short and sweet because I get back to work. But if you're in agreement, don't put your assets on the petition, and don't complete the schedule of assets and debts. I'm sorry, not the schedule of assets and debts, but the property declarations that you file with the court. This goes back to a client that hired me yesterday. They filed their case, they attached the property declarations, tons of assets. And then not only did they do that, which it's not wrong to do, but why would you give that to the court when they don't require it? Then they wanted to update it, and they filed them again separately, not attached to anything, just filed them separately. So not required. I had a gentleman ask me today, hey, I have a bunch of guns. Do I have to list those? And in my opinion, they are an asset, but also in my opinion, and I said, I'll let them make the call, is, do you want that on a settlement agreement that's public record and people know you have guns? Going back to listing assets and debts on your settlement agreements, when we turn in your judgment, we never list full account numbers. We never list values. It's very basic information the court needs. They just need to identify the asset or debt. So if there's a dispute in the future, you can go back to court and say, I was supposed to get XYZ account. And they can go reference the settlement agreement and say, oh yeah, it says that, account number 1234 was your responsibility or your asset, and vice versa. It doesn't matter the value unless you are going to have a certain amount of money going to one spouse from that asset. Otherwise, if it's going to be an equal division, then we'll just say 50% of anything we can do to, keep your identity safe. And I lied. I'm going to talk about one more topic. It might get me in trouble with the courts, but there's a FL 191. I just forgot the name of it, but a client asked, hey, Tim, it says on the judgment 180 that we need to turn in this child support registration form. I think it's called something like that. FL 191, I believe. And while it says that it's required within 10 days of the judgment, I've never had a court ask for that, maybe one or two. But I think we filed one or two in 10, 11 years I've been doing this. I don't think that court should be allowed to have that information. Social security numbers for you, your spouse, and your children. Date of birth for you, your spouse, and your children. where you work, employer address, phone numbers, you and your spouse, driver's license number, state of residency. I mean, it has with that. I think the only thing it's not asking for is your mother's maiden name. What else do you need to open a credit in your name with this form? So I don't recommend you do it. If the court says calls them up, says, hey, we got to turn this in, then we'll have to do it. But I haven't turned them in 11 years. Hasn't been an issue. I don't think they should have that information. So if you're watching this on that, you turn it in, I think you're at risk of having your identity stolen. So anyways, hope you enjoyed Daily Perspective episode 14, Day in the Life of an LDA. Talk to you tomorrow. All right, Tim Blankenship here, divorce661.com. It's Day in the Life of an LDA, Divorce 661 Daily Perspective, episode 23. Moving right along here with these episodes. This, I do a ton of videos, probably 6, 7, 8 a day. I'll have, I think, 3,000 videos by the end of the year. So in about 6 or 8 weeks. 2 weeks till Thanksgiving, people. So always the end of the year seems to come by really fast. Couple updates just to let you know, if you're filing in LA County, the e-file will be down this Thursday. So Thursday from 6 p.m. until Sunday at 6 p.m. So it'll be down for 4 days. Going back to the videos, I have 2,700, almost 2,800 videos. One thing you can do when you're, if you're trying to do your own divorce, you're trying to get help, is use my channel as, you can search the channel specifically. So instead of searching YouTube in a regular YouTube feed, go to my channel and you can actually search my channel, and then you can put in what you're looking for and you'll come up with the video you're looking for, most likely, with the amount of videos I've done. I had a gentleman asked for some help today. He's trying to help his daughter do her divorce, and I just said, hey, send over your reject sheet. I'll take a look at it. And it was an issue with the proof of service. And I went to my channel. I could probably show you. I went to my channel and searched for that. What I know what I would have, talked about, found the video, sent the video and said, here's what this is what your judgment's being rejected. And here's how you need to fix it. So, we do have a full service. So I'd be happy to, you can hire me as well. It's not a free service, but if you need help finding a video I did because you're trying to do it yourself, happy to do that. Speaking of which, I've been considering, and I want your opinion. I was thinking about doing free judgment rejection reviews, meaning you did your own divorce, you turn in your judgment and it was rejected and you got a reject sheet. I'm considering, and let me know in the comments, but I'm considering finding a way for you to be able to maybe upload your rejected judgment, not the judgment itself, not the paperwork, but just the reject sheet that says what's wrong with it. And then I'll do a video talking about how to fix that. Let me know what you guys think about that. Okay. So talked about the e-file being down. Talked about rejected judgment reviews possibly. Today, busy day. Yesterday we had like 12 consultations. Today we've had 6 consultations. 3 of you, not that I consulted with you, but this is part of Tim's temper tantrum. I'm not going to talk about it, but when you call, there's something you need to do before you hang up. I'm going to talk about that at the end of this segment. So what do we got for you? So today I e-filed 4 judgments yesterday with LA County, and I got them all back approved today. So again, we're still getting them done within 5 weeks. We file a petition, we do the proof of service, and then we get the settlement agreement together. And we usually have that done in a week or so. And then I just wait until 31 days have passed from the date of service, which is done by notice and acknowledgement. And then I can e-file the judgment. And we got all 4 back the next day. Totally approved. They're totally done. They're just waiting out their 6 months before they're officially single people. And those are sometime in April of next year. So even though we do get them done in 5 weeks, the 6 months still applies. People ask me that all the time. So for LA County judgments, less than 24 hours, which is awesome. I really feel bad for anyone that does not live in LA County. I'm really hoping that the other counties come on board with allowing us to submit the judgments. I hope they come on board with getting faster approvals as well. Because there's one other county that allowed me to submit the judgment a few weeks ago, is Tulare County, and I e-filed that like 2 weeks ago, and no acknowledgement. Just kind of goes into the oblivion or whatnot. It's not like LA County where you get a confirmation and then almost immediate approval within 24 hours. Drafted 4 settlement agreements today, both the combination of forms and the actual settlement agreement documents. Have lots of cases we're trying to get wrapped up before Thanksgiving. I think people that have already started with us, we're trying to get wrapped up. So I'm getting a lot of people turning in their terms to me. So I'm trying to get to your cases and your files to get those wrapped up so we can get those submitted. Had 2 people get their information to me today. I was able to get their settlement agreements drafted, and all their final judgment forms, had them e-sign, e-notarize, and also e-file those with the court. So those have been submitted. I had a question today from one of the consultations I did about the e-notary service. They said, Tim, I didn't think California allowed notaries to do electronic notaries. And she was correct. California does not allow a notary service in California to do electronic notary. It has to be in person, in your face. But the courts allow for electronic notary. So the service I use currently is proof.com. That's right. If you're going to be my client, that's where I'll set you up with. I have an account with them, and you'll be notarizing your settlement agreement. The trick is that the notaries, I noticed, mostly are in Florida, Texas, Virginia, things like that. So even though you're signing in California, the notary service that they're performing the notary are in another state, and those states allow the notary, and the courts accept that. I shouldn't say the courts. LA County accepts that, as does San Diego. All other courts want that wet signature in state notary service. We had one county, I want to say it was Contra Costa, one of those ones up north. I shouldn't say north, but they one of the spouses was on vacation and notarized. So they're in the case was in California. Obviously, they took their paperwork with them. They had notarized in whatever state, doesn't matter. They go like New York or Florida or something. And when we turned it in, the court rejected the judgment, saying, why was the notary done out of state? Who cares? Like, sometimes the clerks blow my mind with the stuff they come up with. They think that we're trying to sneak something by them, and they think they caught something. Oh my God, they notarized this in another state. It's still notarized. Like, what's the big deal? Just because the address didn't match. And that's what they said. The party lives in California. Why was the notary in Texas or whatever? It doesn't matter. It was notarized. That's just the stuff what we deal with. So I guess that was it regarding that. Did the settlement agreements, judgments, proof of service of amended summons and petition. This is one of the questions that came up. I had actually done a video on this before, but just real quick, and I can direct you to the video. I'll probably just cut out that part of the video for you and upload that. But how to properly do a proof of service when you have amended your summons and petition. It does get tricky, and I do have a video on that. All right, so here's Tim's temper tantrum. We had a pretty fast daily perspective today. Of the 6 consultations I had today, it would have been 9, but for 3 of you who called my office today did not leave your phone number. I can't call you back if you don't leave a phone number. My phone doesn't track your number. It goes through my office and then comes to my desk, and by that time, it doesn't capture on my phone, so I can't just do like a call back. And it's not a cell phone, it's a business line. So I don't know who you are. If you didn't get a call from me today, that's why. Second, Tim's temper tantrum of the day is 2 of the clients hired me today. Both had paralegal services that they hired previously who did not do their paperwork. One of them, I think, was trying to do it and just didn't know how, and just was really messing it up, like really bad. And the other one was, I don't want to say it's a scam service, but took their money, did some of the paperwork, never to call them back again. What I hate about that is, and what makes me mad, and why this is part of Tim's temper tantrum, is this falls back on our industry, my industry, with what I do. When this happens and people call me, like, yeah, we hired someone that didn't do it, or the judgment's getting rejected multiple times. And now they're, the hairs are standing up on their arm. They're like concerned about hiring someone because is it going to happen again? And I totally get it. It just makes our industry look bad. So shame on you if you're taking advantage of people. Shame on you if you don't know what you're doing. If you can't do it, refund the money. I've refunded money to people who it was like super complex, or the parties just fell out of agreement and I wasn't going to be finalized. There's no harm in that. Just, but if it goes crazy, I do my consultations pretty well, to the point that I'm 99% certain that it's going to be amicable. We're not going to have any problems. But where the cases blow up because one spouse goes sideways, they fall out of agreement. For instance, I'll give you an example. We filed an initial petition. That's been filed. They're working on their agreement, and then one party goes out and goes and gets attorney, and for whatever reason they feel like it's not fair or whatever's going on in their world. And so I'll simply, to give a partial refund, maybe I'll get 50% back and just say, hey, sorry, we can finish it as nothing on our end that we did. We couldn't have foreseen this happening, but refund people, it fixes all. So let me know on the judgment reject reviews, going over the reject sheets. In the alternative, what I can do is just get a full reject sheet from each county and go down the list and just talk about each of those reject issues. I could do that as well. I think it's more interesting when it's a specific reject sheet from people actually going through the process, because the reject is going to be specific to what they did wrong. And I think we'll get more out of it. Plus, I'll be able to help people who are like really trying to do their own paperwork, like the gentleman was today. Well, I hope you enjoyed today's Daily Perspective, episode 23. We will talk to you tomorrow, which will be 2 weeks to the day before Thanksgiving. All right, Tim Blanchard here, Divorce 661, Daily Perspective, episode number 24. Happy Friday, November 10th. It is my birthday. Actually, it's not. It actually kind of is. This is the 248th Marine Corps birthday today. So thank you for taking it easy on me. Clients, I think, are on vacation or whatnot, so I wasn't too busy, but we did get a lot done. I don't think some people noticed that I was in the Marine Corps. I have these little subtle hints here. I don't know if you noticed on the hat, 0311, Marine Corps, just a little fun stuff I do, so you can identify who I am and what I do. Also, as a police officer many moons ago, so a lot of background. The 0311, by the way, that's infantry. That's the job you get when you maximize your ASVAB score. Anyways, okay, today is Friday's wrap up. What happened today? Oh, and to the rest of you, happy Veterans Day, by the way. Didn't mean to alienate anyone that was not in the Marine Corps. Today's wrap up. Today, again, wasn't so bad, but still had a lot of new cases. We did 3 new cases, 1 in Orange County. I guess that's wrong. I had 4 in LA County that we filed. 1 was a summary dissolution, 1 in Orange County, 1 in Alameda County. My math is off. So we did file several new cases today. It's interesting. Some days are busier than others. Sometimes Fridays are dead. Sometimes Fridays are busy. Sometimes Mondays are busy, and sometimes they're dead. It doesn't really, the day doesn't matter. It's hit or miss sometimes, but the general volume during the week is generally the same. Completed a judgment package for an Orange County divorce case as well. So we filed 1 and finished 1. Friday stats, 23 consultations overall this week, 10 new clients, finished 15 cases from the following counties: LA County, Orange County, San Diego, Alameda, Contra Costa, San Bernardino, Riverside, and Solano. You guys are all represented. Overall, 10 divorce cases approved by the court, 13 finalized judgments that were submitted to court for review, and 12 settlement agreements that I drafted for clients this week that got me their information. Okay, so that's kind of the stats. That's the updates. I want to talk about a couple different things. I want to talk about custody today, and I'm going to talk about true default, no agreement type cases versus default with agreement type cases. As much as I talk about that, people still message me and say they never knew there was such thing as a default with an agreement. And I'm going to talk about how to stop your divorce case when your judgment's already been submitted. There's a trick to that. So I want to talk to you about custody. People are often, or my clients are often, wondering how specific a custody schedule has to be, number one, and it doesn't. It can be joint legal, joint physical. That's all you need to put in there. Courts don't need a specified parenting plan. To the other end of that, you can be as specific as you want. There's all kinds of additional attachments. I think there's 4 or 5 of them as far as joint legal custody attachment, holiday schedules. I mean, you can become and get very detailed, but it's not required. Sometimes I'll see some very detailed custody plans. I'll say, are you sure you guys want to be locked into this as part of your agreement? Meaning, if you want to change it, you're going to have to modify your judgment. And they said, no, we thought we had to have all the details regarding custody in there because the court's going to require that. It's not the case. Joint legal, joint physical, reasonable right of visitation, and you are good to go. I want to talk about the difference between joint legal and physical versus sole legal and physical and the differences in that. So joint legal and joint physical custody, it doesn't necessarily mean 50-50. Some people think that when you have, let's say mom, it doesn't matter, mom or dad's going to have the child 90% of the time. So they're thinking, well, then I should have sole custody, physical custody, and my spouse should have visitation, whatever that 10% is, whatever those dates are. Just because you have more than 50% timeshare doesn't mean you have to have sole custody or label it that way. You can have joint legal custody and you can have 99.9% timeshare. You have to realize that the custody and the percentages are irrelevant. The joint does not mean anything to do with 50-50, 60-40, whatnot. The only time the percentages come into play is if you're having a child support calculation done, that will affect the child support, the timeshare percentage, but it doesn't matter for the custody part. Sole custody, I had an interesting case this week and been doing this 11 years and never had someone want to do this, but it's totally fine. The male child is going to live with dad and the female child is going to live with mom. I said, okay, that's fine. And so they want to have sole legal and physical custody of the male child to dad and sole legal and physical custody of the female child to mom. And they want to do that so they have sole discretion to do whatever they want, get passports, doctors, all the stuff that goes along with that. You don't have to get permission from the other parent in those cases for certain things like passports specifically. So never put an agreement like that together, but I said, hey, that's totally fine. Courts don't care. That's what you want to do. That's how we'll write it up. So, but you don't have to do that. They could have just as well said joint legal, joint physical, and did the exact same plan that they are doing. Okay, I'm going to talk about a case where we had a client call us and they had a default without an agreement case they submitted to court and it got rejected. Shocker. I tell you, they're the hardest cases to get through the court because it was rejected because of an unequal division of assets to the parties. So I'm going to say this for the 1 billionth time. When you do a default without an agreement, you have to divide the assets equally, even if you don't feel it's fair. That's why I always say use a default without an agreement as a last resort. Whenever someone calls me and we take over their case and I'll say, hey, it appears that the respondent hasn't signed a settlement agreement and hasn't done any of their side of the paperwork. And they said, yeah, we're in agreement, but I didn't want to bother them. No, bother them. That's why you're having so many problems because you're trying to submit this as a default without an agreement, and that falls to California law, and everything has to be divided equally. So when you do, how I tell you don't do the 160s when it's amicable? If you have no option other than to do the default without an agreement, you have to do the property declarations, the 160s, and attach them to your petition, and you have to show them being divided 100% equally. Otherwise, when you go to submit your judgment, the court's going to say, these are not divided equally, these are community property assets, and rejected. And guess what? If you're going to then try and fix that, you're going to have to amend your petition and refile with new property declarations showing the equal division of assets and debts on the 160. It's just a total nightmare. So in this case today, I said, will they agree? And the answer is 99% of the time, yes, they will sign off on it. That's all we have to do. So the question specifically was, I tried to turn in my default without an agreement divorce case. It was rejected because of an unequal division of assets and debts. I already filed the default, request to enter default. Can I now submit a default with agreement judgment case? The answer is yes. How do you stop the divorce process when your divorce is approved, but the 6 months haven't passed? So one of the interesting issues that comes up with our clients, not very often, it just happened today, is because in LA County only, I can get your divorce done in 5 weeks. The approval comes from the judge. It's already signed by the judge at week 5, but there's usually still, because we did it in 5 weeks, there's still 5 more months before you're officially divorced. It's that cooling off period. So in this case, they want to know, hey, can we stop the divorce because we're within that 6-month window? The answer is yes, technically. Procedurally, good luck getting into court, because once the judge has signed the divorce decree, your settlement agreement, your final judgment package, the only way to get that set aside is to go to court and ask the judge to set that aside. So let me give you 2 scenarios here. Let's say I'm handling your divorce. We filed the petition. We're doing the financials. We've even completed your settlement agreement and you've signed it. As long as we haven't submitted it and it hasn't been approved to dismiss the case, you file a request for dismissal. Super simple. Don't go to court. If there was no response filed, only the petitioner has to sign it. If a response was filed, both parties sign it. It gets dismissed, gone. If the judgment's been submitted and it's been approved by the court, and so we're still within that window, now you have to set a hearing. You have to file a request for order to do a set aside, and you have to get the court's permission, and you're probably going to have to get both parties to agree that they want that to be set aside, because there was a settlement agreement signed. Then it's going to be up to the discretion of the court. Yes, you're within that window, but you have to file a motion, get a court date, serve your spouse, go to the hearing. And the problem with this client today, what I told him is the time frame on actually getting a hearing is about 60 days in most counties. So his divorce, it's November 10th. His divorce will be final on December 24th or something, like 23rd maybe. So we have 5 weeks, but the hearings, the soonest he can get a hearing is in January. So there's no way they're going to get into court before that to have their divorce judgment set aside. In fact, years ago, we had someone who it was after the 6 months. The hearing was after. They still wanted to file it, and they went into court and said, "Hey, we want, even though the divorce has already happened, you signed it, and we're past the 6 months, and we're divorced. We want you to set aside the judgment." You know what the judge said? Judge said, "Just get remarried. It's easier." So you got to be careful. If you're on the fence, and this happens once in a while. Let's say we filed your divorce paper. Okay, they're not put the batteries in the lights. Let's say that you have submitted your divorce to court, but and you want to have it pulled because you don't want to go the divorce to go through. Just don't submit it to court. Just hold it. So let's say in the scenario where we had the divorce paperwork all finalized and signed, just tell me, Tim, don't submit it. We're just going to hold off and see how things go. And then I just won't turn it in. There'll be hearings that'll be set. You don't have to go to them. Just, keep an eye out. Send me your notices about what the court's saying. But if you're not sure that you want to be divorced, we just hold off on submitting the final paperwork to the court. So I'm taking off the rest of the day. I'm going to cut out a couple hours early. I hope you enjoyed the episode 24 of the Daily Perspective, Day in the Life of a LDA. Have a good weekend, folks. We'll talk to you on Monday. All right, we're back. Tim Blankenship with Divorce 661's Daily Perspective, episode 11. I hope you're all doing well today. The Daily Perspective is a daily podcast where I talk about a day in the life of an LDA, that's a legal document assistant or preparer, also known as a divorce paralegal. If I worked for an attorney, that's what I'd be called. Anyways, today's, I start these recordings, just so you know, with no plan, a couple of notes that I've jotted down what I did during the day, but I don't script it, as you could probably tell. I literally just hit record and start talking with whatever I'm thinking. So today's been fairly busy. A lot of weird stuff going on in the world, by the way. A little slower this week. I think people had their attention on what's going on around the world with all the chaos right now, which is awfully terrible, of course. Anyways, going to talk about some calls we had today, some consultation issues, talk about how to file stipulations. We're going to talk about why, if you think you are different or weird with what you're doing in your divorce, you're not. I'll give you some examples of that. And we're going to talk about legal separation cases as well. So here's my note. So a lot of times during a consultation, I'll have someone call and say, I know it's weird that we're amicable, or we get along, we're like really good friends, but we just we still want the divorce, or we have some weird agreements because we still want to live together, or we don't want to have alimony and we don't want to have child support, and we just want to each keep our own things. I know that's weird. It's not weird, not with what I do. It might be weird if you are going through a contested divorce and you hate each other and you're fighting for every inch and every second with your child and every penny you could get. That's a whole different story. But with what I do, and because I only handle 100% amicable cooperative clients, that brings a whole different realm of people with a whole different type of set of agreements that they can come up with. Um, Again, we have people that, excuse me, we have people that continue to live together post-divorce. I just drafted a settlement agreement today where they were doing the divorce. We still have to do the custody and all that, even though they're going to live together, but they're going to continue to live together for at least 5 years. And I think it's for financial reasons. It's cheaper to stay together, in many senses, but it's especially for cost of living and people, if they want to buy out the other party and whatnot, they're trying to get the interest rates to come down. So what I want to get across with this is whatever you guys come up with, it's not weird. It's not strange. I'm sure we've done it before. I will look at what you guys want to do and just make sure it's something the court will accept, which in most cases it will be. Just needs to be enforceable. So I'll look at the language. I can even help you with that language. But yeah, I just had a consultation talking about that, where she's like, I know it's kind of odd that we don't want alimony, we don't want child support, we don't even want custody, we just want to do our own thing. With that, we still have to have all of the elements of your settlement agreement in play. So like even with these folks that are still living together, we still have to have a child custody order, we still have to have a child support order, and we still have to have a spouse support order and a property division order. So what we do in those cases is we just make it very generic. We'll say joint legal and physical custody with a non-specific parenting plan, obviously, because you're still living together. We will do no child support, reserved jurisdiction. We'll do no spouse support, because it doesn't make sense if they're still living together and still paying the bills as if they're a married couple. And property division, we will also still list that, and that's usually where there will still be some terms. And in a lot of cases, and not all, but folks want to keep their own assets and debts. That's totally fine. The rules say 50-50 division. Yes, if you're going to court and you were arguing for that and we're in agreement, yeah, that's probably what the court would order. But on your own, even if it's not fair, even if it's not equal, the court's not going to interfere with that. And that's a big concern for clients, as they say, what's the court going to say if it's not equal division? And the answer is they're not. And they're not going to do that because they don't know if it's equal, because we never give them the values of what these assets are worth. We have a bullet point list essentially of, Schwab account 1234, Fidelity account 1234, Chase checking account number 1234, XYC vehicle, no values. The only time we list values is if there's a need to. Like in this one case, everything else was pointed it out for a judgment I did, a settlement agreement I did the other day. But in one account, they were going to get like $180,000 from this 401k. So what we do in those cases, we'll say, okay, Schwab account number 1234, $180,000 to petitioner, respondent, whoever that's going to, because that needs to be detailed in there. This was a brokerage account, so that's not something that would need a quadro for. It's it's going to be treated like a checking account, and they're free to move that money around without the need for a quadro. So, long story short, anything you want to include in your settlement agreement is going to be fine. After 11 years, I've pretty much seen it all, so don't be worried about that. The court's not going to interfere with what you guys are trying to do. Okay, so I was talking about quadro, so I might as well spin into that. Today, I helped someone draft a stipulation to modify their judgment of their divorce. Their case was finalized in 2015, and they wanted to modify spousal support. And that's easily done by agreement through what's called a stipulation. And the stipulation is simply a document, an agreement that says we want to, and it doesn't just have to be spouse support. You can change any terms you like by agreement. And we just draft that's usually a 3-page document that details out what the changes are. They sign it, we file it. A $20 fee normally to make that update. So in this case, the person who had contacted me happened to be the respondent in the case. And when I looked up their case summary online, I noticed that he did not file a response. So when a response is not filed and it's a default with written agreement, which is totally fine, we do that all the time. if we were to file this stipulation in the respondent's name who had not filed the response and therefore did not pay the filing fee for the response, they would have charged $435 to file the stipulation because he's never paid what they call their first appearance fee. So what I said is, you guys are amicable. I'm going to draft the stipulation in your wife's name so she can, they both still sign it, but they count who is at the top of the form, like who is filing the stipulation. So he did it in the wife's name, and then it's only going to be a $20 fee instead of $435 fee. So just a little trick there to save you some money if you find yourself needing to do that. Again, this week, I was asked 3 times, and I got to call someone back as soon as I'm done. I just saw a call come in, and I read my messages. They get transcribed. And the question was, do we do legal separation or do we just do divorce? So for the 5th time, people, legal separation is the exact same process as divorce. I know it's divorce 661. I can't have legal separation 661. Okay. So yes, it's the same process, different checkbox. That's it. Yes, it's technically a faster process because you don't have to wait the 6 months, but because the courts are so backlogged, you're going to be waiting about 6 months anyways before it's approved. So if that's your rationale, and sometimes it is for folks, we want to get done sooner, it's not going to be that much faster, maybe by a month. So if you really want to do the divorce and you're going to do legal separation because you think it's faster, don't. You'll waste your time, you'll waste your money, because once the legal separation case is approved, you now have to file a brand new case number, new court fees, the whole process to go through divorce. So yes, I do legal separation cases. Now here's a topic that I want to bring up. I wasn't sure if I was going to. It's just something that's kind of bothering me, and I'll put it at the end. You might not even have reached this point of the conversation, but when it comes to the consultations, I offer free 15-minute consultations. You can sign up on my website, and I do have options in there. Are you in agreement? You're mostly in agreement. Are you not in agreement? Are you just looking for free advice? And people will fill those out. Plus, it gives me a little bit. I also ask, what is it that you need help with, so I get an idea of what they need, and then based on what they write, I can kind of get an idea of how amicable or complicated the case might be, depending on their question. Lately, just this week, and this is probably a small percentage, so don't take this to heart. 1% of you who have no intention of hiring me and pretend that you are, considering it, keep me on the phone for 30 minutes of a 15-minute consultation and then completely ghost me. And so I'm going to get a little bit more, I hate, what they say, don't penalize the masses for the few, or whatever that line is. But I've had a couple of people this week who, asked question after question after question, and then basically said, thanks, appreciate the information. Didn't lead anywhere. It's a big waste of time. And now they're probably going to take all the information I gave them and go do it themselves, or whatever the case might be. That's fine. I just don't like being tricked into it. Not everyone can hire me. If I do walk through, I do give very detailed consultations. I have other people that tell me, first of all, Tim, why do you do all these videos and tell everyone how to do it? They also say, what do you, when people ask, how do you do this or that? Do you tell them? I said, absolutely. I'm not going to. I think the biggest issue in the legal profession, especially amongst attorneys and even people doing what I do, is to keep information so close to the vest. They're so afraid that if the information were to get out, that you're not going to hire them. And I'm sure that happens. I've had people email me, say, hey, Tim, I never talked to you, but I did watch all your videos. I was able to complete my entire divorce. It took a lot longer than I thought, but I was able to do it. And that's great. Those people were never going to hire me anyways. And people do, I know when people hire me, when they try to do it on their own, and I can tell that they were watching my videos, because I have a very specific flow of how I do things, what I write on the petition for like separate and community property and stuff like that. So when I see that, I just laugh. I'm like, okay, here's people on one hand saying, I don't want to give it all away for free because they're going to try and do it themselves. And they will, like I said. But here's people who did try and do it and follow it. It's still complex, even though I'm giving you the step-by-step details. Every case has some nuance that might tweak the paperwork just a little bit. I can only tell you how to do it in the most generic fashion. You may have some specific thing or you want to do regarding property or the kids, and that might cause your judgment to reject. So where do you think those people are going to go? And they come, they're going to go back to the resource that they were following and looking at my silly face and trying to watch the videos of how I do the forms. And they're going to call me, and that's what happens. And they do. So I will see the paperwork that has like verbatim, like what I would normally write for descriptions of assets and debts and so forth. So I appreciate you. I just wanted to vent a little bit for those of you that intentionally call me to take advantage. I'm on to you. And if you're watching these videos, I've even had people call me and say, hey, Tim, oh, I can't, you have too many videos because I have now 2,500 videos. You have too many videos. I need the video on how to do this. It's like, come on, guys, at least have enough, take the time to research on my YouTube channel to find the video. Don't call me for a consultation for the sole purpose of me giving you a video. That's going a little bit too far. So I hope you enjoyed this episode, the Daily Perspective number 11, episode 11 on this Friday the 13th. You guys stay safe. All right, Tim Blankenship here with Divorce 661 Daily Perspective, episode 8 already. Today's Monday, and Mondays are always crazy busy. Came into about 120 emails from over the weekend and late Friday night that I didn't get to. Had lots of people reaching out, which is great. Love to help you. It just takes me a little bit of time to get to you, but I did get to everyone today. This Daily Perspective is getting out a little bit late because I want to make sure I called everyone back and got everyone set up. So super busy day, like I said. I think we started 3 new divorce cases. All of them have already been e-filed with the court. We finalized 2 judgments today. They were approved by the court, 2 different ones. And we're going to talk about a couple different things today, aside from the type of cases that I took on. We're going to talk about timelines with the court. We're going to talk about the fact that you guys are really doing a good job watching the videos and listening to the content I'm putting out in regards to, sorry, I'm not looking at you, I'm looking at my notes, talking about how to save money on court fees, how to not file the response if you're amicable, not filing your property declarations, don't put in your personal information out there to be taken by someone. We're going to talk about, and I'm going to do a special video on this later in the week, but true default divorce cases where there's no agreement. We had a lot of calls on that where one spouse is not cooperating, not participating, not fighting it, just doing absolutely nothing, which can be even worse than them actually fighting it. We're going to talk about that in another video. We're going to talk about how unemployment is kind of a benefit right now for filing, and talk about restoring your maiden name and certified copies and a whole lot more. So let's get into the topic here. I don't want to waste your time, and I'm going to probably make this one 10 or 12 minutes, so a little bit shorter than normal. So I think my message is getting through to you guys. I just got a notification from YouTube. I've now done 2,500 videos of various lengths, from short videos, 6 seconds to a minute, to up to an hour training, showing you how to do your own divorce. But most of my calls, folks have already watched a lot of my videos, so they already are pretty sold on my service. They just want to double check something specific to their case, a certain question they have particular to them that I'm always happy to do. By the way, you can always go to divorce661.com, and there's a tab for free consultations. You get access to my calendar. So if you do want to chat before you pay me, it's not required, but happy to do that as well. But what I'm saying is people are really getting a lot of good information. I'm glad you're watching my videos and not someone else's, because there's a lot of bad information out there as well. In fact, many of the questions clients have are about, well, this other person said this and you're saying that, which is correct. And of course it's me. But go to the authorities, listen to what I have to say. And what I'm saying is based off 11 years of experience in doing this. And it's more from a procedural tactic in getting your cases through the court when you guys get stuck, or if you're starting with me from scratch, we just getting it done correctly from the get-go. So in this case, we had a client call, well, not a client, a prospective client call that really had it all down pat. Said, hey, we're amicable. I was just about to do my own divorce. I found you, found your videos, found them helpful. I'm glad we're not going to have to file the response and pay that fee since we're cooperative. The court was telling us, because we went down to the courthouse to get the paperwork, and one of the forms is the FL 160 property declarations, and they're telling us that that's required. They are not. That was a conversation we had. So I'm glad that I can save people both time and money and frustration by kind of cutting through to what actually has to be done to get your divorce complete. Next subject. I had another paralegal firm who is only handling one spouse. So I had a consultation today with a gentleman who said, my wife already filed for divorce. She used a paralegal firm out somewhere in LA where they live. And when I called them to discuss, getting through it, they said that they're only helping his wife, and I've talked about this extensively. If you are amicable and you want help getting your divorce through the process, there's no way you can do that through a service that's not going to work with both of you. I work with both spouses. In fact, it's mandatory. If you say my spouse is going to go somewhere else, or they're not going to be involved, or anything else than me working with both of you collectively throughout the process, I'm not going to take you on, because the likelihood of it going through amicably is lessened considerably. So take a look at this. So this gentleman called me because the paralegal his wife hired would not talk to him. And so he's saying, we're amicable, we're talking, we're in agreement, but I have questions that I want to get answered and they won't answer my. So now I need to go find someone to do my paperwork. And that doesn't make any sense to me. So this spouse hired this paralegal firm to do their paperwork amicably, but they're only going to do one side of their paperwork. So that's going to force husband to go out and get someone else. I couldn't help him. I could help him, but again, that's not the practice that I have. I said, you guys are welcome to come both use my service and I can take you both on and we'll, just transition that way. So he's going to talk to her and see if they want to move services over here, because it's just going to set them up for failure. He's going to have to find someone. If she stays where she's at, he's going to go find another paralegal firm or an attorney and get fed up. And then they're no longer amicable because they don't have someone as a neutral third party coordinating the process and answering both their questions. All right, today I was telling you I was super busy. 2 LA County judgments I e-filed today, and they were also approved today. Clients are very happy when we can get their divorce done in LA County in just under 5 weeks. I talk about a lot with the e-filing system. It's been a game changer with the divorce process. It's still 6 months before they're officially divorced. But could you imagine 31 days after you hire me, you have a divorce decree in your hand signed by the judge that has a date typed out saying when the divorce was done. For instance, this client that we finalized today, and by the way, these were same day approvals. Once we submitted the judgment, they were approved. We filed this case back in early August. The date of service was September 5th. I'm just looking at it here. And it's been approved as of today, September 9th at 3:41 this afternoon. And their final divorce date will be March 6, 2024. And that's because of the 6-month cooling off period. That still applies. But this is what I keep talking about. We can get your divorce done before the 6 months. You still be married. So until, what was the date? March 6, 2024. This couple is still technically married on paper, but they have a divorce decree, all their agreements, terms, custody, whatever else is involved in your case, signed by the judge, and they're done. All that'll happen is miraculously on March 6, 2024, they will no longer be married at all. So on top of the 2 LA County judgments we finalized, we had 3 new LA County cases come in and 1 Ventura case. All of those can be e-filed, which is nice. Most counties can e-file, although I just talked to someone in Sacramento County and had to inform her that we cannot e-file with them yet, plus a few other counties in California. LA County, we usually get same-day filings. Of the 3 that we filed, like I said, they were all already filed. The Ventura case we filed usually takes 3 or 4 days to get back from the court. However, the date on it is the date that we submitted. So we submitted on 10/9, and it doesn't get actually processed by Ventura until, say, Friday. What would that be? 9, 10, 11, 12, 13th. Friday the 13th. Then, but the date it'll show filed will be the date we submitted. So we don't lose any time on that. Also want to talk about fee waivers. I filed one of the LA County cases I filed today was a fee waiver case. And this was specifically on the fact that one of the spouses were unemployed. So in this case, the wife had called me and actually spoke with both spouses, and it was determined that one of them was unemployed. The wife was originally going to be the petitioner. And again, it makes no difference in an amicable divorce who the petitioner is. But once I discovered that the husband was currently unemployed, I said, hey, let's make you the petitioner. Again, makes no difference, and we can get your court fees waived. And with the new court fee waiver that was recently updated, they now added unemployment as an automatic qualifier, which is different from before, because in the past, if you said you're unemployed, they'd want to still see it wasn't an automatic qualifier. You couldn't say I'm unemployed and get your fee waiver approved. You would say, yeah, unemployed, as far as, listing the name of an employer, and then you still have to use your income, what you're getting from unemployment, and include your spouse's income or all family income in the household, and that would usually not allow the fee waiver to be approved. In this case, we just marked unemployed. We don't have to do anything else on the fee waiver request, and it was automatically approved. Again, we got same day approval on that LA County case as well. And they didn't even question it. They didn't ask for an unemployment, something from an employer showing he was laid off. They didn't ask for a EDD, something showing income or that he's unemployed. They just took it at face value. I mean, you are signing it under penalty of perjury, so there is that. But yeah, it wasn't verified. But yeah, I thought it was going to take a while to get approved, and it was not a problem. Next thing I want to talk about is restoring your maiden name. If you are going through divorce and you've had your name for a long time, or maybe you have kids and you took your husband's last name, and you, what is very common is that the spouse, mom, will want to keep the last name because it matches the kids' names. And so they won't want to have that restored. Or maybe you just had the name for 40 years. We just did divorce cases. They were married 40 years. So maybe you're more that name than your maiden name. But in most cases, I'd recommend you request restoration of your maiden name. And here's why. When we do the settlement agreement and judgment, there's a section on there where we can mark petitioner or respondent requests restoration of your maiden name back to X, whatever your maiden name was. So the divorce gets approved. Like in this case, this was a similar situation. Their divorce is done, signed by the court as of today, not officially approved until I shouldn't say it's approved, but they won't be officially divorced until March 6, 2024. And she's restoring her maiden name. And she really wanted to get that done. Like, can I do that now? She messaged me, say, hey, I know my divorce is approved, but can I change my name now? The issue with that is, so yes, you do have a court order for that. But what we're learning through our clients is that most of the government agencies, Social Security, DMV, passport offices, are not just allowing you to bring in the copy we get from court. They want an actual certified copy from court. And unfortunately, the courts will not certify your judgment until the actual 6 months have passed, because they know that technically anytime between now and, in this case, March 6, 2024, the parties could go back to court and say, hey, we changed our mind. We're within the cooling off period. We want to stop the divorce. And they will. Easier said than done, but that is a possibility. So until that time has passed, the courts will not certify it, because it is done, it is approved, but the 6 months haven't passed. So in this case, she'll have to wait the 6 months. And then I told her once this date's passed, I gave her the link to LA County to where she can order directly online and get that certified copy, so then she can change her name back. So hope these are helpful. This was episode 8 of the Divorce 661 Daily Perspective. We'll talk to you next time. All right, Tim Blanchett with Divorce 661's Daily Perspective, episode 10, moving right along, where we talk about kind of like a little blog, if you will, podcast, is just the inner insights of what I do. Also talk about client issues, problems that came up, clients I helped, in case you have similar problems. Maybe you'll get some helpful tips in there. So today was one of those days where it just became about judgments. The phones were a little slower. We only had 2 new clients today, but I did receive a ton of judgments that clients had signed and turned in. You can kind of see them. Where's my camera? Right here. So there's probably 12 judgments I received in the mail today. With all other counties other than LA County, we can e-file your initial documents in most counties, but then after that, everything else has to be signed, wet signatures, and I need original documents. Unfortunately, they won't even allow for scanned signatures. So it's not an issue. I mean, that's how it's always been in the past. For the last 11 years, I've done this. Just with the with the e-file with LA County, us being able to submit the judgments entirely shaves off a lot of time for me and for the clients. So when we do our final judgments, once the client's happy with the settlement agreement and all that, I give instructions on how to sign, and they will just sign independently, go to a notary in their town. Again, we work with all clients in California, and then they'll mail them in. So they all just sometimes they just come in big groupings. Sometimes I won't get any for a couple days, and then like today, I think we got 8 or 10 or 12. I mean, I haven't opened them all. I've reviewed them. I try and get them out right away because they're usually ready to go and ready to file. But I made a note of where these cases came from. I'll be finishing these judgments today, and it's from Contra Costa. We had three LA County cases, 2 San Bernardino cases, 2 Santa Clara cases, 2 Riverside cases, an Alameda judgment, a Solano case, a Ventura judgment, and of course, always with the LA County's weekend e-file. So I just took some notes here on what got mailed in. So if you're watching this and you're my client, I am working on them. They will be processed shortly. Going back to timing with the courts, they've gotten really bad with their processing of judgments. I'm usually quoting, and because we have the ability to file all these cases with all these different counties, we probably have, even if it's a county we don't deal with a lot, we're probably at least filing 3 cases a month with them. And so it gives me an idea on timing. And we're starting to see that time of year where we're going to start seeing the delays, because as soon as we get into November, holidays, clerks are taking time off, Christmas, courts are taking time off. There's some holiday time there for folks. So that's going to extend the time. I reported to you, I think in yesterday's daily perspective, that Ventura has shockingly gone to 5 to 6 months for a review of approvals versus 3 to 4. Like generally that's most courts, 3 to 4, just really depends. So we want to get those in as quickly as possible. And again, I'll get through those. They do take me a solid hour to process them because I'm getting them with a signature. Sometimes they're upside down and backwards and all a big mess when I receive them. So I have to package them up, do a final review, make 1,000 copies, and then UPS them over to the court so they can get in review for review and signatures. So that brought me, I had a couple of consultations today. One was by text, which is funny because I get it. Some people don't want to call or have the commitment to have that conversation. So today I had someone text me and they said, "Hey, do you handle this county?" I said, "Yes." "How many cases do you handle in that county?" I said, "I've never been asked how many, from like I'm sure they're trying to get a sense of, I don't know how good I am at my job, I suppose, or my familiarity with that particular county." And so they said, how many have you filed in this county in the last, 3 months? And I don't keep track or record of that. Maybe I should. I don't think it's important, but what I told them was we do about 30 divorce cases a month, and it's just me. So it's, high volume. And of those, I would probably estimate, we handle almost every county in California, not every month, but we have in the past. And of those 30 per month, by the way, over the last 11 years, and it's not 30 exactly every month. It might be, 15 in December or 20 in December, or some of the slower months, maybe when the kids go out of school in, May, June, when they go on summer break, we'll see a little decline, but then we'll see a huge jump once the kids are back in school. So it could be as high as 50 cases, I think we did in September, and it could be, 30 or 20 cases in other months, just depending on what's going on in the world, which is kind of crazy right now. So anyways, I thought it was an interesting question they had about how many cases have I filed. And so I hadn't been asked that before, so I kind of laughed. I don't know how you can laugh on a text, but I just did the little LOL and said, I'd never been asked that before, but here's kind of my stats. And one of the things that their issues were, and this comes up a lot, and I've talked about this a lot, and it was on 2 different calls. One with the folks that we did this consultation by, and I'm sorry, I'm not looking at you, I'm looking at my notes, but we did a consultation by text, and then the other one was a regular consultation. And in both cases today, the folks by text, they had filed, and I don't know who I was talking to. Let's just say he was the petitioner, but the respondent was in Canada. And I've had this happen so many times. And I said, "Oh, well, if you'd called me in the beginning, I would have said, make the person in Canada the petitioner, because then you don't need to get the notary." There's no way they can get out of that now at this point. And we just had a case like this last month where same exact situation, petitioner in California, respondent in Canada. They had already filed. So the only issue is they had to go to the notary in Canada, but you have to go to U.S. Embassy. So that's what they're going to have to do in this case as well. And that's what I told them. The second one today, the wife was in San Diego and the husband was in Ecuador. Doesn't matter where you're at, different county, city, country, state, doesn't matter. As long as you're amicable, there's a way of getting you through the process. So I made the same suggestion to her. I said, look, if you guys are amicable and you trust him, let's make him the petitioner. I always use my business address. So there's a California-based address. You don't, not that we, that's just for mailing purposes for the court, just to make sure they get their copies when the judgment's approved. But the idea was make him the petitioner. We'll still file it in her jurisdiction. You know, the petitioner doesn't have to file where they live. You have the option, file in your county or your spouse's county. So we'll still file this in San Diego. Just making her the respondent, which then avoids him having to get a notary at all. So that's more of a, as far as a technicality and process. Just if you're watching this and you're in this situation and your spouse is, we have people deployed in the military, we have folks in different countries, and they've already separated. China, I've done one in China. I don't want to say just about everywhere, but it doesn't make a difference. We can get it done. There's just a certain way that it needs to be handled from a technical aspect. One thing I wanted to announce is I'm going to start, and I used to do a lot of tutorials to specific documents, the judgment forms and how to file a petition and all that. What I decided to do today is I'm going to go over how to prepare your judgment with all the different variables that could happen, but individual videos for each type of divorce case. For instance, I'm going to do, and I just recorded it today and I'll probably release it today. I just did and I'm going to break it down by county as well. So this is going to probably turn into 100 different videos on judgment prep, because I think there's going to be at least 8 variables for each county, because the counties do handle their judgments differently. Some counties want the forms. Some people want MSA. Some counties want a combination of forms and MSA. Some counties change their mind every other time. We've had one county where we file enough to know what's going on in the different counties in California with the courts, and they'll, one time we filed with using the forms, and they said, "Oh, there's no settlement agreement attached," and we're like, "Yeah, it's the forms. The forms make the settlement agreement." I must have been a new clerk, and they rejected it. It said, "Do a settlement agreement." So we did a settlement agreement and it got approved. I'm like, okay, that was weird. And then I keep notes because I don't want that to happen again. So the next time I submitted a settlement agreement, and they said, "Oh, we have a preference that you use the forms." And sometimes I just have to throw up my hands and say, we're at the whim of the courts, the clerks. And there's multiple departments, so you're not always dealing with the same clerk or court. You never know what you're going to get. I know there's a lot of turnover in the courts as well, so I know that has something to do with it, and it's just their lack of training. And it could just be a judge who wants it done a certain way in their department. And if they change their mind on something, we just have to go with it. So if many cases we've handled over the last 11 years, sometimes we still will get a reject. We're not perfect. Once in a while it'll be, an error, but usually it's the court making some recent change to their policy on what they want as far as the documents are concerned. But going back to the announcement, I'm going to do these variables of, like today, what I did was, it was LA County, so default with an agreement, Los Angeles County judgment, no assets, no debts, no kids, no spouse support. So like the most basic judgment package you could put forward to the court. And we handle a lot of those cases. So, it wasn't like that. We don't ever use that, but did that in under 7 minutes. I actually went quite fast through it. So people are able to, I don't want people to be waiting to, fill out their boxes. They can go back through it. They can rewind it, watch it again, slow it down, back it up, whatever. And I'm going to create within the YouTube, you probably watch in the YouTube. I'm going to create different, for each county, there's going to be a separate, I forget what you call it. I pulled it up just before this, but it'll be broken down by county. And then once you go into that heading, it's going to show you all the different videos. So and I'll tell you, this video is for no assets, no debts, no kids, no alimony. This one is for assets and debts, but no kids or alimony, or, everything, assets, debts, kids, alimony, the whole shot. So because they're different, there's different forms that come into play. If there's child support or no child support, spouse support or no spouse support, assets and debts or none. And there's a lot of variables on that. So I'm going to cover all those, because when you bring in one aspect, it brings in other aspects that you need to address. So that's it for today. I think, let me just check my notes. We're, keep tuning in. Seems people are liking this. Oh, I wanted to ask you a question real quick before you go. Today I uploaded 3 videos, long form videos, like 3 and 4 minutes. They're normally, horizontal like this. But today I did them vertical. And I'm just wondering if you have a preference on how I make those videos. And the difference is with the vertical, because I looked at my YouTube channel today, and the devices that people use is 78% cell phone, which that makes sense, right? But from a tutorial type video like I did today, there's no way I'm going to do that on a vertical video. I'm sure you're not filling out your forms using your cell phone. I mean, your vision would have to be better than mine to do that. I'm sure it's possible, but I think the people on the PCs are probably watching the longer form tutorials, how-tos that I'm doing. But that was it for the update. Again, this was the Divorce 661 Daily Perspective, episode 10. We'll talk to you tomorrow. All right, Tim Blanchard here again. Divorce 661 Daily Perspective, Day in the Life of an LDA. This is now episode 20. I hope you're all doing well this Wednesday. I hope you're not suffering from allergies like I have been. I had to take yesterday off. I was coughing, choking, eyes were watering. Hopefully you can't see how bad I look. But those winds pick up in that heat, and I'm done for. All right, let's get into it. I got in the office today, and boy, was it busy. So here's what we worked on today. Finalized a San Diego settlement agreement. We finalized and started a new case for Solano County. So Solano County, we're getting a lot more clients from lately. So I was able to finalize a judgment package, settlement agreement, get that turned into court. And then we took on a new case today as well for Solano. I completed an entire case for Santa Cruz County. Had someone hire me on Monday, got the case filed, just took a couple hours to get that back. We were able to e-file with Santa Cruz the initial documents. But after that, we have to get that turned in. There's this pretty straightforward case, no assets, no debts, no kids. And we're just doing the dissolution. So when we do that, I'm able to finalize all the paperwork in one shot. Once I have the case number from the court, finalize all remaining judgment forms, settlement agreement, the whole thing. I'll post date certain things because like the request in or default, that can't be filed obviously for at least 30 days after the date of service. So I'll predate all of the forms so they can sign them in one shot, go out and get it notarized, mailed to my office. I'll get it prepped. And when that 31st day comes by, I will turn that in to court. And then that way they're just done right off the bat. They're not going through weeks of working on paperwork at different stages. All right. Took over an Alameda County rejected judgment. Alameda is interesting. They will write I want to say an interesting, but a more specific reject letter. I see rejects from all the counties in California when people have me take over their case. With Alameda County, it's actually someone that's almost like they're writing a narrative. Most of the counties just have like a standard 4 or 5 page judgment reject sheet, and they'll tick off the box of what the issue was, but they won't give you any further explanation. This with Alameda County, we see this all the time. They basically started off like they're writing you a letter, and it says something to the effect of, I should have had a copy of it, but it says, "Thank you so much for turning in your divorce paperwork. We appreciate the amount of time and effort you put in to doing your paperwork. But here's all the problems you have with your divorce and your paperwork." And they'll literally, like, for the issue, say this one of the issues was the petition did not turn in their FL 141, and it not only said, you need to turn in the FL 141, but it said, here's why, and then make sure you mark on this box and that box. And I mean, it was a solid like paragraph of things to do to fix it. And there's obviously multiple other rejects, but we took care of that entirely today, got all of their updated paperwork to them so they can sign, get that in, and then I can turn in their judgment to the court. Filed a new case in San Luis Obispo today, and received copies in just a few hours. So some of these, I don't want to call them smaller courts, but maybe they don't handle as many cases as other counties. We are getting these initial petitions filed quite quickly. In most cases, sometimes the same day, sometimes a few hours. But then we have our oddballs that for some reason, like Orange County, Riverside, which we can now e-file with, it's taking them 3 or 4 days to get us copies. What else did I do today? Took over rejected judgment from Contra Costa and prepared their settlement agreement. So we use the settlement agreement format for Contra Costa. That court prefers those. Those take, they're not any different, just a different format. It contains all the same information as the judgment forms, but That's why when you hear me say I did a judgment package, that's probably referring to the forms. And if I'm talking about a settlement agreement, that's the settlement agreement portion of the judgment package. And yeah, today was busy. So busy. Finalized the judgment package for 4 LA County cases today. So got 4 cases wrapped up, all their paperwork completed, out to them for electronic signatures and e-file. As you know, we can do that in LA County for the judgment. Also finalized a very long Orange County settlement agreement, tons of assets and debts. Orange County allows for the forms, but like I say, when I have a lot of assets and debts and narrative and things they want to include, I'll use the settlement agreement format. It's just easier because we're not trying to fit all this information into the boxes. So that's what I did today. I was up very early, 2:30 in the morning. My brain works in such a way that I'll wake up in the middle of the night to roll over and realize all the work I have ahead of me, and I'll get in the office and just start knocking it out. The more work I get done before like 7 a.m. or 8 a.m. when the phone calls start, I get a lot of work done. Okay, so now I'm going to talk about some issues and things that came up while I was handling these cases today. So this will hopefully help you in your divorce if that's what you're doing. So I have it says here, don't list full account numbers. Okay, so here's what happened here. So had a court actually reject a client's judgment. It wasn't ours. They did their own judgment, and the court rejected the judgment because they were listing too much information in the settlement agreement. They're listing the full names of their accounts, full account numbers, address of the bank. I mean, they're giving them, the court basically said, hey, this is potentially and technically can be public record. You're giving a lot of information, and we're not going to allow you to turn this in. You just need to be giving us the basic information we need. And they said exactly what I've been saying for 11 years. For the asset, you list the full name of the asset and then the last 4 digits of the account number. That's it. That's all they need. So this is the first time I've ever seen a court reject a judgment saying you provided too much information. And I'm glad they're doing that, because it's just scary the amount of information that gets put on these settlement agreements. Even when I worked at the courts 12-ish years ago, and for a law firm prior to that, where the settlement agreements have so much information, even including social security numbers, driver's license numbers, it's crazy. So we go to all extent to keep your privacy as best we can and only give the court what they need in order to sign the settlement agreement. Now, to the other side of that, make sure you're listing enough information to identify the asset or debt. I have a worksheet that I'll send to my clients that ask them to provide the terms of their agreement. And I have a whole sample or example, basically, that says, for vehicles, I need your make, model, and license plate. For assets and debts, I need the full name of the asset, the last 4 digits of the account number. This would be for bank accounts, credit cards, loans, retirements, pensions, everything we need to identify the exact same way. And I had 2 judgments I was working on today, finalizing their paperwork and working on their settlement agreement. And the worksheet that they sent me basically said Fidelity Retirement, Schwab account, this XYZ brokerage, and it didn't have any identifying information. So you don't just say Fidelity, say Fidelity 401k account number 1234, and do that with all your assets. That's how the court's going to want them listed. If they're not identified properly, the court's also going to reject your judgment for that same reason. Okay. The order of forms when you submit your judgment. So this is for the gentleman who texted me today on how to submit a default judgment: no assets, no debts, no kids. That was the text. It's a very long text. It said, Tim, I followed all your videos on how to complete the paperwork. It's a default without an agreement. And I did. This is how I filed it, like you said. And how do I stack the forms? Like, how do you submit the forms to court? So this is going to be specifically, well, it'll be for any case, but I'm going to rattle off the forms that are specific to a default without an agreement. And I'm talking about the judgment package forms. So you're going to have the 180 as a face sheet. And below that, you're going to have the 343 spouse support order and the 345 property order. That will be stapled together. That's one item: 180, 343, 345. That's going to be your settlement agreement. You're going to have the 190 as a separate document. You're going to have the 170, that 3-page document, as a separate document. You're going to have the 165, the request under default, as a separate document. Am I missing anything on the default? I think that's it. just the judgment itself, the settlement agreement is just those particular court forms for the settlement. In that case, it's going to be the 180, 343, 345. Every other document is a standalone document and will not be attached. And it's a good question, actually, because I had one of the judgment rejections I took over today. The court rejected it because, and I'll tell you, they rejected it for anything. They rejected it because they didn't list the appropriate or correct number of pages that followed the 180. If you look at the FL 180, you'll see on the bottom of page 2, it says how many pages are attached. They wrote 13. And the reason they wrote 13 is because they put everything behind the 180. They put the 180, they put their settlement agreement, they put the 170, the 144, the 141s, they put everything behind that. That's not how that works. All those forms are standalone. So their settlement agreement technically was only 3 pages. All those other documents they had listed behind that page 2 of the 180 were actually standalone, separate procedural judgment forms. Okay, next subject. There are no requirements that you live apart or even move out prior to filing for divorce. I'll get people telling me, Tim, we haven't filed yet because we haven't officially separated yet. You don't have to. The other question that comes up is if we're still living together, what date of separation do we use? Well, use a date of separation that you guys talked about the divorce. Use a date of separation where you started living in a separate bedroom. Use a date of separation of just the day we file the paperwork if there's no previous date. And keep in mind, if you guys are amicable, cooperative, like all of our clients are, the date of separation isn't going to be as critical as it would be, say, in a contested case where you guys are fighting over everything, because regardless of the date of separation, you guys can decide how you want to divide up your assets. Whereas normally the date of separation, I shouldn't say normally, the date of separation is the line in the sand for the division of community property and separate property. But if you guys are in agreement and you want to use dates other than that, that's going to be fine. Whereas, say, in a contested case going to court, they're going to use that date of separation for division of all assets and debts to make those decisions for you. And the reason I brought this up is we have clients today want the settlement agreement that I drafted today. And this goes to parties making interesting decisions regarding housing and selling the house or refinancing or buying out the house, is that they are deciding to live together until December 2026. So we're talking 3, 4, 5, is that 4 years? 3 years. 3 more years. 24, 25, 3 years are going to live together. And I don't, this is the don't ask, don't tell office. We don't ask what's going on or why you're doing things. You tell us what you want and we'll get it done. And my assumption on this is, like many of our clients who have homes are trying to avoid having to refinance where one party wants to keep the house or maybe buy out the other. They're coming up with these agreements to refinance. I talked to you about one last week. They're going to wait 5 years to refinance and do the actual buyout. We have people staying together for a year. This is probably the longest. They're going to stay together for 3 years. The goal is they're probably very amicable. They still wanted to get the divorce done. We still put custody orders, and they didn't want any spouse support or child support, which really wouldn't make sense if you're going to continue to live together. They're both self-supporting. They were in the agreement, we're splitting up certain bills that they're going to pay. One's going to pay the mortgage, one's paying utilities and all these other bills. And that's fine. They're going to have a living arrangement for the next 3 years. And hopefully interest rates will come down to the point where they can then do that buyout and move on with their lives. So that's a possibility. I tell folks, don't worry about the court getting involved with what you want to do. Tell me what you want to do. I'll tell you if it's possible or not. Tell me in plain English. I'll write it up the way it needs to be written up. And that's all I got for you guys. Thanks for joining me on episode 20, the big 2-0 of Day in the Life of an LDA, the Divorce 661 Daily Perspective, episode 20. Talk to you tomorrow. All right, Tim Blankenship here with Divorce 661's Daily Perspective, episode 21. What I do in these videos, if you've been watching or have been watching rather, is go over what I've done for the day, cases I've taken on, issues that clients are having with the courts, and we will go through all that, and hopefully you will learn from that. So here's the brief recap of what happened today. I took on 6 new cases, 3 of which were brand new cases. They hadn't filed anything yet. 3 were people having trouble getting their divorce finalized, and hired us to take over and finalize their paperwork, which we're always happy to do. Judgments that we submitted to court today, we had 3 Santa Clara judgments. Nice thing about that, because I have to mail file those, is that I was able to fit them all in one priority mail envelope. So that was nice. 1 San Diego judgment that was mail filed as well. Kern County judgment. 3 LA County judgments were e-filed, Sacramento judgment, Orange County judgment, and I think I already said Kern County. Must have had 2 of those. Rejected judgments. So Torrance took on a Torrance rejected judgment case. And interesting, the reason I wanted to bring this up is that even though a response was filed in this case, the court still wanted the parties to notarize their judgment because they were terminating spouse support in a long-term marriage. So the reason the courts do this, and they do it every once in a while, and let me back up and just say, generally speaking, when the response is filed, you do not need the notary. You only need a notary of the respondent when it's a default with a written agreement. But if there's an appearance, which is the response, a notary is generally not required. But I have seen the courts require a notary, even though a response was filed, when you're doing something, I don't want to say out of the ordinary, but you're doing something where it's going against public policy or the court's rules. So the issue with this is in marriages of long duration, they're married over the 10 years, the court will generally retain jurisdiction over the issue of spouse support indefinitely. And so you would mark reserved jurisdiction in case one of you wanted to request support at some time in the future. Very popular. Many of my clients want to terminate the court's jurisdiction, even though the general rule is for it to be retained, meaning having that ability to award support. So in those cases, the courts will want to they know you're signing it, they know there's an appearance, but they want you to notarize it so there's evidence. So if you try and go back to court and say, hey, I didn't sign that, or I didn't know what I was signing, they can say, look, not only did you make an appearance and file a response, but you also both notarized the settlement agreement. So that was what was interesting on that. We generally don't have an issue with that because I'm usually having both parties file their or notarize their paperwork anyways, because we're doing that default with written agreement style. And we are, I'd say at least 80% of the time, maybe higher, 90% of the time, people in long-term marriages are terminating jurisdiction over support. So that's totally fine. All right. Also with this rejected judgment. So this was a Torrance rejected judgment they took over. That was one of the issues. There's multiple issues with their case. And I want to talk about, and this is not just with Torrance, this is not just with LA County, this is going to apply to all courts, is I keep hounding on you guys to please do not file your property declarations, the FL 160s, when you have an amicable divorce. It causes all kinds of problems. The rejected reject sheet that LA County provided for this case was saying that they were not addressing all of the assets and debts they had listed in their property declarations that they previously filed, both on the petitioner side and on the respondent side. And specifically, what had happened is because their judgment was being rejected multiple times, that they actually had sold their house before they submitted their judgment to court. So, but when they filed for divorce, it hadn't been sold yet. They put in their property declarations to say, hey, 50% of XYZ house. But when it came time to do their judgment, the house had already sold, so they didn't feel the need to list that in the settlement agreement. And that was one of the reasons the judgment was rejected, because they didn't list the house that was in the property declaration. So if you find yourself in that situation where you've already filed the property declarations, but then property no longer exists, it could be a vehicle, a credit card, anything you listed on the property declaration, even if it's gone, you still need to address it in the settlement agreement and put in there who kept it, or if it was sold, or whatever the case might be. So if you haven't filed your property declarations and your case is amicable, just don't do it. It'll save you a lot of problems from happening. Okay, so we had 2 cases in the last 2 days where they wanted to state that their spouse will stay on their health insurance plan. And it was interesting that it was 2 cases this week. So what they were trying to do, when one case, the settlement agreement terms they provided to me was that spouse A will keep spouse B on their health insurance until for 3 years past the divorce case. The other one was for 5 years past the divorce case being finalized. And you can't do that. Once your divorce is finalized, the 6 months has passed and you're officially divorced, you're no longer a dependent and therefore can no longer be on the health insurance of your spouse. And that's nothing you can change by putting it into a settlement agreement. The courts years ago, and I've talked about this before, people said, well, can we try it? And I said, sure. And of course it got rejected because you can't put in something in there that's going against public policy or rules, and that being the dependency issue. So one thing you can do if you're trying to extend the amount of time you're going to remain on your spouse's health insurance is simply delay the final divorce date. We can do that in a couple of ways. We can just submit it later on. We can make the date of service of the petition further out so the clock doesn't actually start ticking until a certain time period. We've done that in the past where we're trying to, maybe not for health insurance purposes, but they want a targeted date of their final divorce date. Sometimes if you have kids and they want to do taxes one more year, this usually happens around April, May. Each year we can target the divorce. We can kind of force it to finalize at a date in the following year by just delaying that jurisdiction date, the date of service of the petition, that will force the 6 months and a day into like January 2nd is what we usually do. But that, as far as health insurance, you cannot remain on there. We cannot put it in the agreement. Let me say it this way. We can't put in the agreement that you're going to cover your spouse, or the spouse is going to remain on health insurance for 3 or 5 years post-divorce. But if you end up doing that, I don't know if that's legal, not legal. If you just forget to tell your spouse that, or sorry, you forget to tell the health insurance company that you've been divorced for 3 years, I'm sure, there's people that do that. I don't know what the financial consequences of doing that are. I did a different video last week where I it discussed your options as far as COBRA, getting a separate health plan, or even having your spouse pay for your health insurance plan for a period of time if that's the intent, or maybe you guys can split that. All right, next subject. I had a case, a judgment. One of the judgments I took over was a Riverside case. And the issue they were having when they submitted the judgment is the summons was done incorrectly. Now, the summons is really hard to get wrong because there's not a lot of information that goes on there. It's really just your name and the petitioner's name, the respondent's name, and your name and address at the bottom of page 1 of the summons. This is the FL 110. But the error was they didn't list their name and address at the bottom of the summons. So what's happening here is when their reject sheet they sent me they'd hired me to take care of this for them. It basically had to start over their divorce case because the summons and petition were not filled out correctly, mostly the summons in this case. And so the court said in the reject letter, you need to amend your summons and petition, refile, reserve, restart the 30 days, refile the default, all of that, because the issues of the summons being wrong. And basically they left out their name and address at the bottom. That's it. That's causing them and their entire divorce case to have to start over from scratch. We don't have to pay court fees again. We can amend it. Not a problem. But you hear me always harping on why it's so important that the summons and petition be correct, because that can cause the judgment to be rejected. And I also tell you that obviously, when you filed your summons and petition, the courts are not reviewing that. I tell you guys that all the time. The court is not reviewing your paperwork. Aside from your summons and petition being totally blank, they're probably just going to accept your money, take your fee. Obviously, the clerk would have saw this error. They still stamped the forms and gave them their filed summons and petition because that's what they're told to do. They're not supposed to tell you, hey, this is wrong. They're not supposed to give quote unquote legal advice. So this is going to cause a delay in this client's divorce case because it's automatically going to start over the 30 days because we have to be refiled, reserved, and because we're doing this as a default with agreement, we have to let those 30 days go by again, even though they're in agreement, before we can submit the default with written agreement type divorce case. And the issue this is causing them is she's actually trying to buy a house, and she can't do that until the divorce is finalized because she told the lender about the divorce case. So now they want the divorce to be completely done because their concern obviously is if there's going to be child support paid or spouse support paid. Even if they show the settlement agreement to the lender's still going to want to make sure that's signed by the judge. So now this is further delaying her ability to buy a house. This is how important it is, folks, to get your paperwork done correctly from the very beginning to include the summons and petition. Next subject is the fact that the courts do not always do the same thing every time. Like the standard of the divorce process changes from court to court and even from clerk to clerk or judge to judge in the same county. So I'll give you an example. So what I'm talking about here is we had 2 identical cases that were default. Let me give you the facts. Default without an agreement, so no agreement between the parties. The other party was not filing a response or participating at all. The complication was there was children involved. and we have to address custody, obviously, spouse support and child support and all that. And now we fall back into those rules where you can't, because there's no agreement, no, the respondent's not signing anything. So it has to be, the judgment has to be based on how you file the petition. So in both these cases, we filed a petition with the petitioner having full legal and physical custody, reasonable right of visitation to the respondent, because I've talked about doing the no, if you have no custody to the respondent, the courts will generally want you to set a hearing. We did have another one of those this week where we had to set a hearing for the client, and they just want to know why. Why are you assigning no custody to the respondent? They'll usually approve it, but only after a hearing. They want to get some testimony on the record. But here's the facts again: default without an agreement, child custody, sole physical and legal to the petitioner with visitation to the respondent, no child support, et cetera, et cetera. One was in Van Nuys, one was in downtown LA. The Van Nuys one went through just fine with no child support, reserved jurisdiction. We've been talking about that. The exact same case downtown, they rejected the judgment saying that child support was not addressed in the petition, and therefore you cannot request it to be reserved in the judgment. Here's the interesting thing about that. The petition does not address child support. The child support, you don't put no child support. There's not even a box to address child support or to make a request for child support. So one case got approved, the one in LA did not. So now we're going to have to figure out, okay, do I try and send them the case that was approved in Van Nuys and say it should be approved? Because specifically what they're saying is the child support was not requested to be reserved in the petition. And it was saying that the health insurance on the judgment we said was going to be paid 100% by the petitioner, and said that was not asked for in the petition either. And those things aren't normally addressed in there at all. So what I'm probably going to end up doing is going back to the way we used to do it before the reserved jurisdiction, submit a disto master calculation showing there's no child support based on 100% timeshare to the petitioner, and do a non-guideline order and try and submit it through that way and see what the court says about that. I'm hoping they don't ask for a hearing to be set. They might. It's the court's discretion to do that. And if they do, then, that's just the courts are going to do what they're going to do. So we'll have to just work around that and do whatever they tell us to do. But yeah, we'll try and get that submitted and in. And I hope you enjoyed episode 21 of Day in the Life of an LDA, Divorce 661 Daily Perspective. If you guys need help with your divorce, I can take care of it anywhere in California. You have a good day. We'll talk to you tomorrow. All right, Tim Blankenship here, Divorce 661 Daily Perspective, episode 15. Got lots of action-packed information for you today. We're going to talk about tips, tricks, things I did today, clients I helped, cases I worked on, and hopefully you learn a little bit from what we got going on here. So let's get into it. And here's just a brief overview. We're going to talk about some different county timeframes. We're going to talk about lots of things regarding other people that do what I do and maybe don't do it as well. We're going to talk about Social Security. We're going to talk about how to list certain assets on your judgment. We're going to talk about uncontested cases. And I'm going to tell you about how you possibly could turn your spouse support payments back into having to claim it as income if you use a cash app. So let's get into it. So always busy day here today. Let's see what we worked on. I had finished a San Bernardino judgment today. I got that submitted and out to court. Also finished a long, detailed Santa Clara divorce case, or a marital settlement agreement rather, today. Update on Alameda County judgments. I had one approved in about 45 days, which is definitely, I think we had one that was 30 yesterday and this one was 45. So pretty good little time frame there for Alameda. Some courts, as you know, are 3 and 4 months on the average and up to even 6 months, which is crazy. Okay. And then we also submitted a judgment contra Costa. I'm trying to say that right. Contra Costa. I always say Costa and people get mad at me. Okay. So let's talk about the first client I addressed and worked with this week or today. That was an issue. So this was someone who worked with another paralegal service, and I found out who it was. And I will not reveal their name, but they were an LDA, so they were registered and bonded and all that good stuff, and should have had the know-how and knowledge to prepare a simple divorce case. When I say simple, it was your basic divorce. They were amicable, cooperative. assets, debts, kids, spouse support, child support, a regular old divorce. So the client said they had a prior service and could I take over because they can't get it through. There's been multiple rejections. And I said, sure. Well, they sent over 86 pages of rejected documents with so many errors. I couldn't believe it was done by someone in my industry that should be trained. So I guess the takeaway on this is just because they're an LDA doesn't mean they have the experience or know how to get your case finalized. And what I'm guessing here, so this person, I looked them up and they were one of the first 10 LDAs in all of LA County. So I'm not going to say who they are or give their LDA number, but they were probably doing this for 30 years. I don't even know when the first LDAs became. I'm sure they do. But I think this is just, if you don't keep up to date with the changing policies and processes with the court, if you're not doing it often enough, I don't know if maybe she had retired and not done it for a while or what the issues were, but I've seen people who don't do this for a living do much better. Like clients that come to me say, hey, can you take over? We're getting rejections. Their paperwork was better. So I don't know what happened. I don't know why it was such a mess. I know I'm not going to get into the age thing because I'm going to be there one day and I'm probably someone will be doing a video about me doing the same thing. So just make sure who you're going to hire is going to do a good job and, has good reviews and all that. But for me to review 86 pages of just rejected, I'm just going to start over. There's so many errors. I mean, for the simplest of errors, even the requesting or default was getting rejected because the proof of service was wrong. So when I went to review the proof of service, they said that, Mary Jane served the paperwork, but then Mary Jo signed the actual proof of service, just like the most bizarre thing. The person who did the service didn't sign the form. Someone else signed it. You can't, it was bizarre. I see some crazy stuff, and I was just surprised to see it to come from someone who does what I do. Okay. So next topic. When you hire me, trust that I know what I'm doing. Trust that I've been doing this 11 years. Trust that I know what forms, what check boxes, what gets attached, what doesn't. Because if you're going to hire me, I'd expect you to allow me the courtesy of your trust. I had some clients today who have questioned every single form, every single checkbox. Shouldn't it be this checkbox, not that checkbox? And I don't feel like I should have to, even though you're my client, explain to you why I'm checking these certain boxes or why I'm using these certain forms. Just know that they are the forms that are needed to file your divorce and finish your divorce case. You can, as a reference, I sent them the FL 182, which is the California Divorce Judgment Checklist, so they can see that these are the required forms. But I don't mind explaining the process, of course. But if you're saying, Tim, shouldn't it be this box because of that box? Because I read on this website through this court or that court or someone else's blog or video that it should be this. And it's always no. These folks don't know what they're doing. And I'm just saying it gets a little frustrating to question everything I do when I know what I'm doing is correct. So just a little rant there for you. Let me do my job. Okay, next topic. Just because you file a form with the court and the court puts a stamp on it, that doesn't mean it's approved. The clerk's office is not the judgment assistant or judicial assistant that works in the courtroom. The clerks that take your money stamp your forms, and this is everything from the petition to your declaration of service to your income and expense declaration. I don't care what it is. The clerks are not reviewing it. They're just stamping it. They could be completely blank and they'll probably just stamp it. They're told not to give legal advice, and instructing people on how to do the forms is technically legal advice. So that is not their job. So I bring this up because I had clients today who said, Tim, why are you amending this form? And I said, because there's an error on it and it's going to cause the judgment to be rejected. And they say, well, that's not true because the court accepted it. The court didn't accept it. They put a stamp on it. Nothing is reviewed until you turn in your judgment. Then the judicial assistant will pull your entire file, review all documents, and then you'll get your rejection. Maybe your judgment's okay. I doubt it. But maybe, let's say the judgment was fine. Prior documents will cause the judgment to reject. And because they haven't been reviewed until you turn in the judgment, that's why if you've been through this or you're going to submit your judgment, the judgment could get rejected for half dozen or a dozen reasons because there could have been errors on your petition, your proof of service, any procedural document that you filed prior to the judgment. Okay, next topic, Social Security and how it works. I've talked about this before, but people come to me and say, Tim, we agree on everything but Social Security. He or she wants my Social Security. You should really do some homework and look it up. If you look up the IRS or the Social Security, tax code or whatever it is, it literally says if you have been married longer than 10 years, your spouse or you, depending on who you are in this process, can claim 100% of your own or 50%. I'm sorry, let me start over. You can claim 100% of your own or 50% of your spouse's, whichever is higher. And your spouse will still get the full 100%. So there's nothing to fight over. So I'll give you an example. Let's say you're going to get, I'll make it simple. You're going to get $100 in Social Security, but your spouse is going to get, $1,000 in Social Security. Obviously, your spouse makes more than you. So you would want to claim 50% of your spouse's, because then you'd get 500 instead of 100, and your spouse would still get 1,000. They are not affected or impacted by that. So just keep that in mind. Okay, next subject is listing assets on your property order. You need to be specific, but not too specific. And what I'm talking about is not giving the court too much information, just enough to what they need to know to be able to make a decision on who's keeping what. So let's go over it. Bank accounts, credit cards, loans, anything like that. You're going to, student loans, you're going to use the full name of the asset so it can be identified. And then all you need to do is put the last 4 digits of the account. You don't need the full account number, and you don't need to put the value unless money is being divided by a certain amount, or if they're dating half or something like that. If you need to state the amount, then that, it would make sense. But you don't need to put you're keeping, 100% of XYZ account with $2 million in it. The court doesn't need that information. Vehicles, year, make, model, license plate is required when listing a vehicle. And also, if you have a vehicle, you probably have a loan in most cases. Don't forget to add the loan. We see people, like today I was doing a judgment and there was 3 auto loans, but they didn't list any vehicles. So I had to reach out and say, it appears there's some cars and some vehicles. I'm going to need the year, make, model, and license plate to be able to list those. They just happen to forget those. So just a helpful tip there on listing your assets and debts. All right, what do we have next here? Okay, uncontested divorce cases. What I mean by that, and I want to state this by saying I only handle cases where parties are amicable, cooperative, and will sign off on everything. I understand the level of being amicable is going to depend, but you can hate each other, but are you going to be cooperative in the process, reach an agreement, and sign off on the paperwork at the end? That's all I care about. That's the type of clients I work with. I don't handle cases that are going to court. I had a gal call me yesterday. Can I say gal? Lady called me yesterday saying, I want to come to your office. I need to file paperwork to go to court. And I said, well, why are you going to court? Well, I have to do this paperwork before I go to court. I said, why are you going to court? She goes, well, everyone goes to court. I said, no, my clients don't go to court. And she said, what do you mean? I said, our clients reach an agreement out of court and you don't go see a judge. And she was so taken back and surprised by that. She just assumed it was, you go, if you get a divorce, you're going to court. So it turned out the issue was the right reason she was saying going to court is when I said, are you guys amicable? Yes. I said, are you in agreement? She says, no, we don't agree on anything. I said, well, then you are going to court. And I had to explain that I don't take those types of cases. I don't take cases, she was arguing with me saying, I just want you to do the paperwork. And I said, I understand. I don't handle cases where you and your spouse are not both working with me and are cooperative and amicable. And she couldn't figure that out. I had to say it like 10 times that I'm not interested in helping her, because when, in my opinion, if I were going to take on a case that's not amicable and parties are going to court, that in some way is going to force me to have to give this person legal advice or strategy, or, here's how you can take advantage, or whatever attorneys do when they're going to court. And as legal document assistants, we cannot give legal advice. So for those of you, and it's interesting, I have a lot of people that listen to these podcasts and my videos who are in the industry. I think you're taking a real chance by taking on clients who are not in agreement and are going to court, because you are having to give legal advice. You're going to have to write motions that, bring up the law and reference to kind of give them, to explain why the judge should order in that, in their favor. And so I'll tell you, 11 years doing this, there's plenty of business to go around for couples that are amicable. Let your competitors handle the people that are going to take a lot of your time and energy and effort, and let them handle it, is, I guess, my advice for that. Okay, lastly, Venmo. So I'm going to do a short video on this. There is a CPA that did a video that's talking about sometime next year or November, I forget when the date is, if you use a cash app like Venmo and you receive money in excess of $600 at any, it could be $600 in one shot. It could be $10 a day for, 80 days or whatever. But once you hit over $600, you're going to trigger the IRS to send you a 1099. So if your spouse is paying you spouse support through Venmo, you're going to get a 1099 that year and have to explain to the IRS where that income came from. They're just going to assume, according to this video I watched, that is income. It doesn't matter if you sold clothes or where that source came from. But let's say you're getting, $6,000 a year in spouse support and it's being paid by Venmo. You're going to get a 1099. You're going to have to attach that to your tax return, probably pay more in taxes to have that form filed, but then show and document evidence of why that's not considered income. You'll be fine. You'll be able to show that it's not income because it's spouse support and it's not collected or it's not counted as income, but you're just going to have to go through that drama of having the IRS send you a 1099 saying that attach this as income to your tax return, which you don't want to do. So Venmo, Cash Apps, you're not going to want to use that. They were saying that what you can use is Zelle. Zelle does not trigger that because it's a bank-to-bank versus a third-party cash app. Enjoy your Friday. We'll talk to you next week. This was the Divorce 661 Daily Perspective, episode 15, Day in the Life of an LDA.